Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now. It's so good to be back and to see all of you. Go ahead, put your questions in the comments. And boy, have we gotten some really good news since I have been out. And of course, if you're following me, I'm pretty sure you've also seen the news that I've shared with you on video. I want to go ahead and answer some questions now about those. I'm sure you all have a lot of questions about all the good stuff that's coming. So I know previously, we saw where Biden had implemented a restrictive immigration policy at the border, and then it's just so nice to see that we do have some fair, just policies that are being implemented to assist those who are already here, specifically college graduates and spouses of US citizens who originally could not qualify for adjustment of status. Usually, it would apply to those who maybe came across the border without permission and they have no proof of entry into the country. They will soon, around the end of August, September, they will soon be able to apply for a special program that will allow them to apply for the work permit, get what's called parole in place, and then apply for adjustment of status, apply for the green card. So this is excellent news, better than I could have ever imagined. I mean, we definitely want more. We definitely need more because there are immigrants here who are not married to citizens, who do still need, who work hard, who are honest, who are contributing, that do need assistance. But it does go to show the progress that President Biden is willing to make in the effort to implement fair, just policies. So, if he wins the election, I'm sure we'll see a lot more to come, but this is definitely a good start. So I wanted to just get more into detail about what this means. So now with college graduates, that's another big deal. It's not now college graduates who are here, you even if you're out of status, if you don't have your papers, they are now looking at still granting you a special waiver, special forgiveness for maybe overstaying to still get your visa. Now, the Department of State, they're in the middle of hashing this out. I believe they are doing some information sessions and FAQ sessions about this that I'll be attending. But what this is going to entail in a nutshell is they are going to allow the individual to apply. So the employer still has to petition. The employer still has to submit that I-129 petition on behalf of the employee, the student, the college graduate. And when it's approved, it will still be forwarded to the Department of State to be determined whether the visa can be approved. Now, if it's not able to be approved, they will then allow the individual, the college graduate, who does not have their, maybe out of status or may have an inadmissibility here, they will allow them to apply for a special waiver that will be considered by the Department of Homeland Security. And at that point, once the Department of Homeland Security approves the waiver, then the person, the college graduate, would be cleared to come to be able to live in the United States with their status. Now, there are some pros and cons here with the waiver process and regarding getting forgiveness for any inadmissibilities. One is that, yes, the waiver will be approved here, but this still may involve the immigrant, the college graduate, having to leave the country to get the visa at the embassy in order to return. I know a lot of people don't like to take those risks. And one of that one of the things I do as an immigration attorney is I help people to stay here to get their papers without leaving, because I know they don't like to face this risk. However, this is where you will really need to make sure that you are represented by an attorney who can walk you through the risk involved, because the risk will be higher, for some, depending on the circumstances, of course. But once a waiver is going to be approved, once the waiver has been approved, your risk would become much lower that you will be able to re-enter the US with the proper visa, to be able to continue to have your work papers here and move forward, living and working here in the US. But I am thinking this is going to be very similar to what's called I-601A waiver process, where the employer applies for you. In this case, the employer applies for you. You get a decision on the petition. It gets sent to Department of State. They then determine whether you qualify for a waiver to get forgiveness for whatever, an overstay or whatever inadmissibility. And once it's approved, then you would have an okay to get your visa and then come back into the country with it. So that's what is going to be happening for college graduates. Now, for those, say, who've overstayed, I know I've spoken to so many individuals they've just had unfortunate situations happen where they made terrible mistakes during the process and ended up overstaying their time here in the US. That's the only thing that stopped them from moving forward. This would fix that situation for them, where they would be able to get forgiveness for whatever little mistakes happened, and then they would be able to re-enter with a visa and move forward with their life, with the college degree that they earned, that they worked so hard to get. So that's, as I learn more, as they hash the details out on how this process is going to be for college graduates, I will definitely let you know. If you have questions, let me know too. And I can see if I can answer those based on my experience, based on my knowledge, or based on what I learned. Now, for spouses of US citizens. Right now, the benefit is only for spouses of US citizens. I know I had one question that said, is this for all spouses of US citizens? And here's where I would say there the benefit, the real benefit of this parole in place program is for spouses who normally would not qualify for adjustment of status, right? Because being the spouse of a US citizen who came in with a visa, say you came in, maybe you overstayed, maybe you're here on your visa right now, you can easily get up and apply for adjustment of status. But there are situations where there are certain spouses who may not have come in that way. You may not have come in with a visa. You may not have come in legally. You may have crossed the border without permission. You may have, somehow you may have driven across the border. You may have come in by a boat. You may not have been granted official parole at the border when you came in, and now you're married to a US citizen. For those of you who don't qualify to apply for adjustment of status the regular way, you would be able to apply for the work permit and parole in place. So parole in place, which gives you special permission to be here in the US, to live here. It gives you basically lawful stay in the US, gives you the ability to get your work permit. And then after that, once you get the parole in place, you're able to apply for your green card through adjustment of status. Because once you get that special permission, it's like getting permission. It's like getting that legal entry into the US that you needed in the first place to get adjustment, to get your green card. So this is where it's going to be truly beneficial for those spouses who normally would not qualify for adjustment of status. It is a big deal though, because there are over 500,000 spouses of US citizens who don't normally would not qualify for adjustment of status, but now can, based on this new policy that's going to be implemented. So, is it beneficial for all spouses of US citizens to apply for parole in place? Probably not. I mean, those of you who came in with your visa, you can just jump straight to get the green card. You can get your green card in less than a year. For those of you who you don't usually you would not qualify for adjustment of status, without the parole in place, this is where it's going to fix that situation for you. Now, of course, keep in mind that you do have to show that you were married to the US citizen as of June 17th, 2024, and that you have been living in the US for the past 10 years. So this is also not for people who have been living here for less than 10 years. It is for those who have been living in the US for at least 10 years and who are married to US citizens, and you've been married to a US citizen as of June 17th, 2024. So as we see more details, of course, they're going to require spouses of citizens to who qualify for parole in place. They're going to require them to submit special forms and follow a specific procedure. And I'm keeping an eye out for when that is going to be released. But what I do encourage you to do now is get on it. Get legal advice now. Get started now. Schedule your appointment so that as soon as everything is announced, we can hit the ground running for you and get this done. Now, I do represent my clients and spouses of US citizens in the parole in place process. This is what it is, right? What Biden is offering spouses of US citizens is a parole in place process. And this was normally granted to spouses and immediate relatives of military members. But now he's expanding it to spouses of US citizens in general. So we've gone through this process with our clients, so it's not anything strange. It's just that it's going to be available on a broader scale, not just for relatives of military members, but for spouses of US citizens who normally would not qualify, who don't have legal entry or wouldn't qualify for adjustment of status. Now, usually with this process, when we submit, we do have to submit the forms. They are going to, because the number of applications is going to be, it's going to be a very high number of applications. I do anticipate that they're going to have a central location for these applications to go into. But normally what we would do is we usually apply to the local field office for the parole in place permission. And then we have to submit, of course, proof of the relationship. In this case, we're going to have to show proof of residency in the US. So they're going to require that, or in the past 10 years, you have to show these documents. And it's going to vary. It could be medical records, it could be school records, it could be bills, it could be sometimes taxes, payment of taxes. It could be all sorts of documents to show that you have resided in the United States for the past 10 years. So that's definitely going to be on there. And then usually this is discretionary, right? That means that it's usually granted on a humanitarian basis. And so a part of this is also hearing from the US citizen spouse and the reason why they would like their spouse to be granted this parole in place. So that's very important in the parole in place process for spouses of military members. and it probably will play a role in the process going forward in this broader parole in place program that's going to be taking place in just a few months. So there's really no room for error here. We're right before the election, and Biden is handing an opportunity of, I would say, even a lifetime. This is the biggest form of relief we've seen since DACA. And so there's no room for error here. This is where I say you definitely get in touch with us. Let us work with you to get this done right, because it's right before election. You don't want any unnecessary delays. You don't want to have any delays or potentially have any obstacles in front of you as a result of anything leading up to the election. So it's very important to get on the game plan, get on this, treat it with urgency, because this is really a big opportunity that has, I would say it is as close to amnesty as I would think we could get at this point. Maybe we'll see something more after the election. All being well, the right side wins. We'll see something more. But right now, this is very similar to a form of amnesty because it's granting a whole population of people who normally would not qualify for the green card here in the US to stay in the US and get the green card. Now they can based on this opportunity. Now, this does also include, by the way, children of US citizens, stepchildren of US citizens. So, not just spouses of US citizens, but children. So, right now, what we're seeing is college graduates, children of US citizens, stepchildren of US citizens, as well as the spouses of US citizens. So, get on it. All right, so now I'm going to answer some questions. Go ahead, put those questions in the comments, and I will go ahead and answer. Let's see. So, hello, my T visa application was sent last May 10th and still no receipt notice yet. Is that normal? No, it's not normal. Receipt notices usually come, I would say during the busy time, you could see, I've seen it go as long as maybe 4 months, but not a whole year, over a year. Can a parent get a work permit with an overstayed visa? Can a parent of a US citizen, the US citizen is age 21 and older, and they're petitioning for their parent? Yes. But just being the parent of a US citizen alone will not get a work permit. You have that US citizen has to be age 21 or older, and has to be either petitioning for the parent or the parent has to be applying for VAWA based on mistreatment by the US citizen son or daughter who's 21 or older. So definitely give us a call though. Let's see what other options there are, because I do look at alternative options for my clients. So yes, right now we have really good news for spouses of US citizens, but keep in mind that I am also in the business of looking for alternative options. There are still alternatives out there that I look for clients who don't have spouses, US citizen spouses or US citizen parents. I still look for those alternatives, but we do need to talk to you to figure out what those alternative options could be. Um, when I'm doing VAWA, how long it take? I don't, I'm sorry, that sentence is a little uh, disconnected. Can you repeat it? How can I contact your office? Thanks. I have a bunch of questions. Just go ahead and give us a call. Go to the link in the profile. You'll see the link tree and you'll see all the information to get in touch. It's really easy. You'll also see our phone number in the caption. So it's very, very easy to get in touch. Link in bio. and link in the description of the video on YouTube, Facebook, and link in bio on TikTok. Do I need to file I-765 for my kids under 21? Yeah, if you want them to have a work permit, you're going to have to file that I-765, yes. My I-94 has expired, but I applied for change to F1 status and still waiting for a result. I just got a job overseas and will have to leave. What can I do not to lose my B2 visa status? So this is more involved. Since you've already done a filing and you're potentially in the middle of it already, you definitely need to do a consultation on that one. Am I here for 5 years? No, I'm here for 5 years now, married to a US citizen, divorced 2 months now. Am I qualified? So since you've been here for 5 years, unfortunately, now keep in mind, remember what I said before, that if you came in with a visa, right, this parole in place process is not, it's I wouldn't say it's more of an advantage for you because you can just jump straight to the green card. But now you said that you're divorced, so you've been here for 5 years. So parole in place, no, because you've not lived here for the past 10 years. However, you divorced your US citizen spouse 2 months now. Did that US citizen spouse mistreat you? If that US citizen spouse mistreated you and that led up to the divorce, you can qualify to apply for that green card without that spouse. And we do exactly this for our clients, right? So give us a call, schedule an appointment, let's get started. Now, very important you hear this one. You're divorced for 2 months now. You have up to 2 years after the divorce to apply for the green card without this spouse, even after divorce. You only have 2 years, so the clock is ticking. So get in touch with us. Let's confirm you qualify and get started. I would say it's urgent at this point. My son just graduated from UCR until now, still waiting for the work permit that we renewed. So yes, you just have to check with the immigration service on that. My daughter is 18 and now a graduate with scholarship for college. Is she qualified? So this is for college graduates. No, college graduates, as in you have a college degree and you're going to be sponsored by an employer to work in the field that you graduated with, right? So you're working in, say you graduated with an engineering degree and now you're going to become an engineer, and an employer is now petitioning for you to become an engineer. That would be a qualifier for this new program that's going to be in place. But it's not for high school graduates or those who are just going to college. Hi there, child of God, Mackie. So nice to see you. Thanks. Thanks, Queen Neeks, for the follow. I appreciate it. Can you get work permit, green card, possibly travel documents after overstaying at J1? How long will it take to get? So, we've gotten this for our clients, but this is an extremely broad question because it really depends on the circumstances involved. All of this may be possible. Work permit, green card, travel documents may be possible after overstaying at J1. But we would need to figure out what happened that caused the overstay. Do you have a 2-year foreign residency requirement in place? Who are your relatives? So there are a lot of questions that we'd have to ask to figure out if any of these would work in your case. But it is a possibility. Um, Good day. What if I'm in the US from the 5 months and waiting on my son to turn 21 in October? So, parents of US citizens, he can still be petitioned for by the US citizen who is 21 or older, even after an overstay. So, I don't know what your circumstances are, but overstaying your visa while you wait for your child to turn 21 is not necessarily going to stop you from getting the green card, as long as you can show that you entered the country with a visa legally or with a permissible visa. How long I take to get my work permit after I do my fingerprints. So it's all over the place. It depends on what type of application you're applying for. If this is marriage based, 3 to 6 months after applying. If this is VAWA, then you're looking at about 6 to 12 months. How long after judge ordered removal do you have to appeal? Usually 30 days. Um, how long to get receipt notice after filing I-212? I'd say 2 weeks. Um, okay, I sent my application for T visa May 10th, 2024. Okay. I didn't receive my receipt notice. Is that normal? That's it's fine. I think you still May 10th. I mean, it's a busy time. It could be busy. If it goes, I would say if it goes more than 2 months, then it's time to start asking questions. But this is what I do. Whenever I send my clients documents off, I track them. I use the couriers to make sure that I track it. I track when it's delivered. So I know that it's there. And then at least I have proof of delivery to know that they got it. And so then I have a hunch, well, maybe things are a little busy right now and we'll get it soon. And more times than not, I just end up getting the receipt notice. It might just be really busy right now. If you're seeking asylum and the judge ordered your case dismissed without prejudice, what's the best step without reopening the case? So now they do have a procedure in place that if they terminate the asylum in the court, you can still go back and reapply for asylum again so that you can move forward with your asylum claim outside of the court. So they do have a special process and instructions to go that route, and then you'll be able to apply for your work permit after that. So this is where, though, it's very important to make sure you get legal advice. I filed for asylum while overstaying on my visa, and how many days will I get the answer? So we apply for our clients electronically, so we get it instantly. How long does K1 take? A year and a half to 2 years. I'm a legal resident. If I become US citizen, will my husband qualify for new parole? Married 2017. If your spouse lived here in the past 10 years, so if he's been living in the US for the past 10 years, um, and then you became a citizen now, you it just depends. How long was your spouse living here? If they were living here for the past 10 years, you're now a legal resident, so your spouse doesn't qualify now. But if you become a US citizen and then they can show that your spouse can show that they were married to you as of June 17th, 2024, then it's a possibility that later on he may qualify. But that 10-year residency, as of 10 years, as of, by the way, June 17th, 2024. So they're not, you have to show that from as of June 17th, 2024, that spouse was here for 10 years. So that's going to also be very important. How long after filing adjustment of status will receive a notice? About 2 weeks. It's been 2 years since I filed VAWA. So yes, and now it's been 2 years. You are supposed to also look at getting your work permit. That helps you to get your social security number and get settled in while you wait for the green card, because you have about another year left. How long after NIV accepts your documents do you get an appointment? I did petition for my mother. I would say about a year and a half. I have everything for PIP, but I have permanent bar. What can I do? So this is where it's very important to schedule an appointment with us so we can see if there is a way to overcome the permanent bar. Parole in place can be a way to still gain the work permit even though you have a possible permanent bar. And I do know that they have listed out some potential obstacles to getting the parole in place. It is discretionary, but we'd have to look to see what are those specific obstacles to getting the parole in place. So this is where it's very important for us to go through your situation to determine if there's a way to overcome the permanent bar. How long does K1 visa take to get approved? I'd say 9 months to a year and a half for the whole process. How long does it take VAWA? So VAWA is a multi-step process. So you're looking at from filing to green card about 3 years now, 2.5 to 3 years. First, you go through the VAWA work permit process where you can get your work permit, your social security number. Those are 5 years right now that you can get those. Then after that, you have time to settle in, build your life here, move on with your life, and then you will be able to get a decision. And then they move on to giving you the green card after that. So the entire process, you're looking at about 2.5 to 3 years. However, you do get those benefits while you wait. I'm on H-2B visa. I want to file for myself. What can I do? You have to qualify to do that. And it really requires a lot of qualifications. You would have to look at, because to be able to petition for yourself, you either have to be an investor, you have to show that you have the education necessary for the sponsorship, or the exceptional or extraordinary ability. So those are some of the ways that you can apply for yourself, but those are very involved and would have to have a detailed conversation with you to determine whether you could fall into one of those categories. Waiting for U.S. Embassy in Sierra Leone. It is 1 month since approval. When is her interview? So the interviews can take now it's nice when you get that notification saying documentarily qualified. However, that's just one part of the battle. Once you get that documentarily qualified, meaning that you have all the paperwork in, they have everything they need, the next thing they're going to say is they're going to schedule the interview. And a lot of people think that means tomorrow they're going to get the interview. Unfortunately, I'm seeing these go for a year to a year and a half until that interview comes through. So it is a frustrating time for that right now. Is there a way to obtain a work visa for my girlfriend from Colombia? Now, if your girlfriend has an employer who is willing to petition for her, then yes, but not you as the significant other, as just a boyfriend or girlfriend will not be able to do that. Will not be able to get a work visa for them. An employer has to do that. What about filing for T visa and still living with spouse who they filed against? Yes, we've done this for our clients, and it is confidential. So we've successfully done this, and they're safe, they're fine, and everything is going well for them now. I am in Boston, Massachusetts, and a U.S. citizen. My wife was approved by Immigration and Visa Center. Congrats. But I don't see what the rest of the question is. How long does it take for VAWA I-765 approval? I'd say right now, 6 months to 12 months. Thank you so much. So peace and blessings, my sister. I hope this message finds you in the best of health and spirit. Thank you, and congratulations to you and your spouse as well. What is the process for a T visa? I have been financially, sexually, emotionally abused by my employer. I'm so sorry. And this is exactly what we help our clients with. So, the process, we can go ahead and explain this process to you. Just give us a call. Let's talk about what you've been through, and then we can talk about a customized plan for you to go through to make this safe, confidential, and as easy as possible for you. But what I can tell you, it's confidential, it's safe. You don't have to worry about retaliation here. The All the agencies involved are also very careful about keeping your confidentiality and keeping you safe. So give us a call. Let's get started. Don't wait. We can do this for you. We've done it for our clients, and we can do it for you. Um, Married to a green card holder, at what point during the filing do I return home having overstayed? This is a hard question just because after you've overstayed, it's hard to fix it. So this is Give us a call. Let's talk about what's going on in your situation and be able to see if we can help you with an alternative that can allow you to stay here. But if you overstay and then you return home, you may not be able to get your visa to come back into the US. So case is ready to schedule for an interview. So it means that that's the next step. Married to a green card holder. So I answered that. Um, oh, I'm so glad. I can't wait to speak with you there. Thanks so much for scheduling. I've been mistreated by my employer for 4 months. I'm looking to apply for my T visa. Get in touch with us. And one thing I want to say, I know you said 4 months. It doesn't matter. 4 months, 1 month, 1 week. If you've been mistreated by an employer, by anybody who made you do things that you did not want to do, then you can qualify for this. It doesn't matter how long, how many, nobody should even stand an hour of this. Nobody should go through even 1 hour of a situation like this. So get in touch with us and we would be more than happy to assist you. Married for 12 years. Husband has a double re-entry in 2009. Would we qualify for parole in place? So this is discretionary. Now, this does mean possibly a permanent bar, right? With double entry without inspection could mean permanent bar. However, parole in place could still serve as temporary relief to get the work permit um, for the next 3 years. And maybe this program might be renewable going forward in the future. We'll have to see the specific details here in regards to how the permanent bar will play out here. But the permanent bar will stop your spouse from applying for adjustment of status unless there is a way to overcome it in another form. So this is where it's very important, though, that if you do have a permanent bar, we need to talk about it. We need to figure out if there are other ways to overcome that permanent bar. But parole in place may still be available. It's just that adjustment of status may not be. Good afternoon. If you don't have a stay in the US, can you travel to Boston? So I'm not sure what that means. Does this include people who pass a US nurse's exam but overstayed? So if you got a degree from, it could, if you were a US nurse who graduated with your degree from an accredited U.S. university or institution of higher education with a degree, so like a bachelor's of science in nursing, then yes, this could very well also include fixing that situation and getting the H-1B to be able to work as a nurse. Now, one very essential part of this, by the way, is as a college graduate, you still do need to show that you will have a petitioner, that you're going to have an employer petitioning for you. So that's still not left out of this. That is still very much going to be a requirement here, because it's the employer who has to file the petition in the first place. Who's qualified to apply for a T? So there are a number of individuals who can qualify for Ts. It is so broad because trafficking itself is such is so broadly defined, and it comes in so many different forms. What I do like to say here is, if you've ever been here in the US and you've been mistreated because you did not have your papers, you were forced to do work. It could be work in somebody's house, could be work in a friend's house that you didn't want to do, it could be work in acquaintance's house, your landlord's house, employer's house, work in a restaurant, group home. It could be in any setting where you found yourself in a situation that you really didn't sign up to be in, but you felt like you're trapped or lured into that situation. You are underpaid, you're overworked. Um, then you can possibly qualify for this T, right? If you've been mistreated in any way based on your immigration status and felt like you were forced to do things you did not want to do, anything you didn't want to do, it's time to check whether you can qualify for T status here. Because that is how broad trafficking is. And this is what is happening to a lot of people here. It is so common that it is scary. And I want people to know that this is not supposed to happen to you. You have rights. People can't force you just because you don't have your papers. People can't force you to do things you don't want to do. And this is where you can qualify for relief here. Okay, so my husband just got approved for I-601A last month. Can he get adjusted in the US? So this is a great question. Now, if your spouse qualifies, so remember the requirements here is, did your spouse live in the US for the past 10 years? If he can show he's lived in the US for the past 10 years, he's been married, obviously he's been married to you since as of June 17th to 2024. If he meets that criteria, then maybe I-601 wouldn't be the best move forward. It's going to be to adjust status. But he has to meet those specific criteria, and he has to then go back, apply for parole in place, and then once the parole in place is approved, then apply for adjustment of status. So it might be a game changer for those spouses who are waiting for I-601As to be approved. Maybe I-601As now will not be the thing. It's going to be the parole in place, right? So we'll have to see going forward when they release more information. But if he meets the criteria, 10 years residence in the US, living in the US, been married to you as of June 17, 2024, then adjustment of status, getting the green card without the need to leave is going to be the best bet here. Hi, I'm a US citizen engaged to an immigrant. What should be done first? So if your fiance is here in the US, you'll probably have to get married before you can do anything else. Being engaged isn't gonna fix the situation, but being married is. So what I would say is definitely get in touch. Let's talk about a game plan for you and then move forward. I have a permanent bar and a judge granted me termination of removal. Do I qualify for Biden's PIP? If you have a spouse, if you're the spouse of a US citizen and you've been here for the last 10 years, then PIP could be on the table for you. Now, you do have the permanent bar, which still could pose an obstacle to adjustment of status. But I never like to say never until I actually can have a conversation with you and we can determine that the permanent bar, there is no way to, or there is a way to overcome the permanent bar. But PIP is discretionary and it could still very well be on the table for you if you meet the requirements for the parole in place, spouse of a US citizen or son or daughter under 21 of a US citizen, and you've been here for the past 10 years. All right. So my wife is a born citizen and had sent in I-130 over 9 months, waiting for approval. Should we file any other documents in the meantime? If you are in the US, then you should be looking at adjustment of status because the I-130 isn't going to get you the green card. If you're outside of the US, then you have to first wait for the I-130 to be approved first and then move forward at the embassy. Once it's approved, they'll send it to the embassy for further processing. But whether you're supposed to file more paperwork or not is going to be dependent on whether you're here in the US or you're outside of the US waiting. My family has been waiting over 3 years for her VAWA green card. The lawyer kept telling her she just have to wait because USCIS keep pushing back the waiting period. So yes, it is taking around 3 years, I would say. Um, you know, unfortunately, that's what's happening. It is a long processing time. My child is a resident. How long will it take for him to file for other who is out of status? So this is where it's very important to get a consultation because your child, um, as a U.S. citizen child, may have limited ability to petition for others who are out of status. uh, if the child is a resident, they can't petition for their parents. So that's out of the question. They can't petition for siblings. The only person they could petition for is a spouse or their own child. And this sounds like they're a child themselves. So they would first have to become a citizen first in order to petition for parent, citizen, and become 21, age 21 or older to petition for their parent and or their spouse or their siblings. But now keep in mind, if they petition for siblings, it's a 14-year process. So it's more complicated here than I think you may know about. So it's very important to schedule an appointment and let's talk about, what are the goals going forward. All right. Hi, can I call? Absolutely. So now I'm going to go ahead and I'm going to put our phone number in the comments. And let me on the, I'm going to put this here too. So on the screen, I just put the number here going across our screen on YouTube, on Facebook. You'll see the phone number, call the phone number there. And on Instagram, I'll go ahead and put our phone number in the comments. So just look here, you'll see immigration lawyer Sharifa. Call that number. It's also all over my videos, I believe. It's also in the caption. The numbers in the caption of the videos. So the phone number is there. The link in bio is also there. So give us a call. We're here for you. We're here. You can also message us. So message, you can DM us, message us, call, whatever you're comfortable with. Okay, so please let me know. My husband have been married for over 8 years. He was ordered deported, never been in any trouble with the law. Will the new law apply to us? It possibly could be. Now, he was ordered removed, but there are ways to get what's called PD. So it's prosecutorial discretion, and then turn around and get that parole in place. So there's a possibility that we could turn this around, but we'd have to determine what happened here, the circumstances, before we can determine how to approach this. But it's a possibility that this can be overcome. What is the process to stay in the USA if I came on J1 visa and my visa is to end on July 30th? So it's not automatic. You have to qualify, and that we'd have to figure out what else you qualify for. What's the cost to do a motion to reopen a removal case? So this is a complicated situation, and we definitely have to do a consultation with you to figure out what your circumstances are, and then we can provide you a code. Can my daughter apply for her stay here at age 18 after my divorce with her US citizen step? She's been here for 3 years, at age 15 after marriage. Let's talk, because now your child is 18. Were they mistreated by the step parent? If they were mistreated by the step parent, VAWA is still on the table. And VAWA can allow, they have up until age 21 and sometimes after 21 to apply for it. But we have to understand the circumstances here. So this is where we need to have more detailed conversation. Can a US citizen who is receiving government assistance petition for their spouse? Yes, absolutely, they can. Now, the number one concern there is usually if you're getting government assistance, it's indicating that the spouse is below the poverty line. And in order to qualify for the affidavit of support to show that the US citizen spouse can support their immigrant spouse, they have to be above the poverty line. So in this case, if they don't qualify to show the correct income, they need to have a joint sponsor, someone else who can step in. This can be anybody related to either the immigrant spouse or the US citizen, a friend, family, acquaintance who can step in as a joint co sponsor to show the income needed to support the immigrant. Can someone on asylum cross to EB2? Now, when you're in asylum, it's your status is in limbo. You're not in status, you're not out of status, and so that can be a big obstacle for the EB2 to be able to get the EB2. All right, that's going to be it for me today. Thank you so much, everyone, for your time. I will be back. I'm working to be back tomorrow at around lunchtime. So, what I say is follow me. And as soon as you see me go live, follow, subscribe. As soon as you see me go live, you can join me and ask your questions. Thanks so much, everyone, again, for your time. I'm really excited for the options that are coming down the pipeline, and I'm going to keep you posted on everything that's happening. And I urge you right now, take advantage of the opportunities that are being presented now. Don't sit it out. Call us, schedule your appointment so we can come up with a game plan and hit the ground running for you. All right, have a great one. Bye bye.